3, 2, 1. Sir, over to you. Sir, you are on mute.
Hi, very good afternoon to all of you, and this is good opportunity to have discussion on this important topic of equalization levy, which is being discussed for some time, and we are hearing different versions, views from media. But it will be good to hear from experts how it is going to be impacting the sector, so to say, and also considering taxation as a complex subject, especially when it is cross-border companies getting affected. And also, it is not very common in so
I think
tax,
somebody's mobile phone is interfering.
yeah. So if people can mute, then I think it will be solved. So tax is not limited within government and companies sphere, but it goes much beyond that. So it is being discussed at government level. So multilateral issues also crop in. So we need, I'd say, uh, always there will be benefits and trade-offs, costs. So some will be visible, some will be invisible, benefits as well as costs. So these kind of discussions, I think, help us in seeing things holistically, or I'll say our perception improves of seeing those costs and benefits. So I am seeing this discussion making us more wiser in that aspect. And there are a good number of experts here talking to us. Mr. Akhilesh Ranjan, who's ex-member CBGT, is there. Mukesh Bhutani, who is founder and partner for BMR Legal, will be discussing a report which ASSOCHAM has commissioned with them, and we will see what's the outcome of report and recommendations. This discussion will also, I'll say, help ASSOCHAM frame its position on this important issue, so that we can decide our plan, how do we want to engage government with the common industry position. Dr. Rajat Kathuria, Director and CEO of IER, is also here. So we will be benefited from his experience and his uh, thoughts around it. Amit Rena, who is partner of PwC, he will also be sharing his views with us. So I will not take much of the time, and we'll straight away go to the substantial part of this discussion. So over to you, Varun. Thank you.
Thank you, sir. Can I request Shri Akhilesh Ranjan ji, retired member CVDT, to make his address?
No, I'm not. Yeah, yeah. Okay, now I'm audible. Um, good morning, everyone. Nice to see you all again. How are you, Mr. Kathuria? No, no. Mukesh, of course, is now a standard feature of all these webinars. Okay, so thank you so much for inviting me over and having me here on this panel. Uh, let me straight away launch into the topic for today. Well, we're talking about equalization levy, and as Mr. Ashwani Rana said, yes, it's a something which has been talked about in various forums, in various manners, sometimes heated debate, sometimes wanting to know what it's all about, but really the topic of discussion. But I think what is important when we talk of equalization levy is to first be very clear that it's not just a tax that we are talking about. It's not just a new tax. It's not just a new way of taxing any particular income. It has several aspects attached to it. It has economic aspects. It has political aspects. It has its own place in international negotiations. So it's a result of several competing forces. And because of that, then there is not much point in discussing as to whether the technical aspects of how good a tax is it. there's not much point in saying whether it's a direct tax or an indirect tax. How does it affect? Uh, Similarly, there's not much point in discussing whether is it constitutional? Which part of the constitution is it covered under? And finally, not really worth going into the question of whether it's a income tax or a consumption tax. I think I think what we have to realize is that this is a tax which has been necessitated by circumstances unfolding, by the world events, by the way businesses are moving, by the obsolescence of certain concepts of international tax. So it's in that light that we must then uh, examine uh, the utility of this tax and the relevance of this tax. um, of course, the basic elements of any tax, basic principles must be complied with. We must have neutrality. We must have efficiency. The two main pillars on which every tax proposal must stand. As far as efficiency goes, I don't see any problem at all in equalization levy. It doesn't seek to influence or persuade any changes in taxpayer behavior. It should not give rise to, in fact, any changes in taxpayer behavior. Um, it's in fact an option that is given in the law that you either go under a corporate tax framework, or you have this network. An easy way of complying with the law and paying a tax upfront. So it's not really something which influences taxpayer behavior. It doesn't influence choices, and hence I think there is no question that it can be inefficient. It does appear to be an efficient tax. On neutrality, of course, one can say that yes, it is a tax only on non-residents, and also only those non-residents who do not have a permanent establishment in India. So therefore, it has a restricted applicability. Um, but then again, does it really discriminate between different types? And that's the issue that can be debated. The way it is structured in the Indian law is that the equalization levy is, again, as I said, an option, an alternative to corporate taxation. Because the moment you come under equalization levy, that income is under law exempt from income taxation. So, if that is the case, then this seeming deviation from neutrality does not really become that relevant. So, I think on both these counts, there is not really much to say that there is a flaw, a basic flaw in the tax. However, one must admit that it is not a perfect tax. It is an imperfect tax, uh, but then, as I said, which has been brought about by an imperfect world, and an imperfect world of tax, where the rules are 70 or 80 years old, where those rules have never envisaged such businesses coming up in the modern world. So that brings us to the second question as to how relevant is it? Is it really necessary? What is the purpose of this tax? Is India going to gain from this? Particularly in the view of the fact that we have recently, in March 2020, while passing the Finance Act to 2020, uh, considerably enhanced the scope of this equalization levy. When it came in 2016 in India, it was at that time more of a political statement. The first year got us only about 300 crores of revenue, which many people ask me that, look, why go into all this trouble for $50 million? I think, but then again, that was not the point. The introduction of the equalization levy at that point of time was a statement, a policy statement from the government of India, where in the post-BEPS scenario, where no consensus had been reached on whether the new digital economy was posing challenge or not, then the basic question itself was not agreed to by countries. And in that situation, India had to make India, which has already always been maintaining that we need to replace obsolete rules with something which is much more relevant. So we had to make a statement, and we made that. Surprisingly, there was not much of a reaction at all because people understood that there is something broader behind this tax. It's not just a levy. which can be talked about. Um, Shortly, there was the European Union, which made its own proposal. Other countries, France, UK, Italy, Spain, all of them trying to come up with their own digital services tax. And now I believe we have countries like Indonesia, we have Turkey, we have other countries which are following suit. So, so what makes it relevant? The relevance is that there was there has been no way of taxing certain incomes which multinational digital enterprises are earning from a jurisdiction, because these enterprises do not have to depend upon a physical presence in that country. And if there is no physical presence, then the existing international tax rules don't work. So there had to be a way of taxing income uh, where there is no physical presence, but there is something being done in that jurisdiction, some economic activity, something which is adding to the value of the service which is being rendered, something which is generating profits. And on all these counts, the option of a straightforward levy appeared to be a very practical way of addressing this problem. Uh, because many countries started off this in this process, I think the global community, realized that something has to be done. The G20 then wanted a solution, a consensus solution, and they tasked the OECD to bring it up. And that has been going on for the last 1.5 years. You are or 1 or 2 years probably, um, and various approaches, various proposals, a unified approach brought out by the OECD, which is being discussed and debated. All these are, I think, now something um, which are trying to address the problem in different ways. Uh, India, of course, is participating in the discussions, and we hope that we will reach a consensus solution soon. But then the point that we must consider now uh, is there really a good chance of achieving a consensus solution? Uh, we have been discussing this topic for the last 5, 6 years. Countries, in fact, are losing patience. Many developing countries are now saying that, look, forget it, let's have a simple, straightforward withholding tax or a digital services tax. And the US is not helping things by first announcing in December 2019 that look, now they are not so comfortable with what they had started. It was they who started this proposal of let's depart from the arm's length principle, let's think of a dedicated nexus. And now they said that no, we're not comfortable with any of these concepts. Um, and very lately, very in recent times, again we are aware of the US stand saying that they don't think that the discussions are leading anywhere, and that probably we should take a pause and come back to the whole thing. So one is not very confident of the possibility of a consensus solution really emerging. And in that scenario, it is that context really, I think, which has persuaded the government of India to widen the scope of the levy on 31st March this year. Uh, Whether it should have been done or not, it's something that can be debated. But from a taxman's point of view, I can say that things on the revenue front have been very, very bad. You're all aware of that. For financial year 1920, our tax collections and direct tax have gone below even the revised estimates. The revised estimates, let me say, had factored in the reduction in corporate tax rate, but the actual collections were even lower. So there is a problem there. And in the current year, of course, again, you're aware of that in June, the tax payments by corporates have not been the same level or substantially short of what has been done, what was there last year. So things are bad on the revenue front, and government does need the revenue, and there is no way, no discussion on that point. And it's very clear. If we have to fight the COVID menace, if we have to bring this economy back on its rails, if we have to go into economic stimulus, then a lot of money is required, and government resources are required. And for that, therefore, revenue generation has to be there. And so I think that has been an important thing also while expanding the scope of the levy, and aim being to gather more revenues from this sector of the economy, which seems to be the only sector which is doing extremely well. But then there are other aspects, and I have friends here, Mr. Mukesh and Amit, who will probably talk about the compliance hassles that the levy is throwing up, the questions that are still unanswered. Some rules have been notified, some forms have been notified, but there are still a whole lot of things which are not clear about the levy. That's something that must be done very quickly, and it is causing a lot of concern to corporates. And I think those are the areas that we must look at very closely in the times to come. So that's where we are. I think that's the perspective in which we must look at equalization levy today in this 1 hour or so. I think we'll be hearing different viewpoints, different perspectives of this levy, and but then as all I would like to submit is that we must realize that it is not just a tax. It is a political statement. It is an economic statement. It is something which has come out of international discussions in a way that was not intended, but trying to force or to persuade global opinion into a general direction. So I think that's what I would. That's enough for me at the moment. I would like to, in fact, hear more from Rajat and from Mukesh and others as to what their perspectives are. Thank you very much.
Thank you, sir, for your address. Can I request Shri Mukesh Bhutani ji, who is also the knowledge partner and has come out with a report with ASSOCHAM on this tax, to make his presentation?
Thank you, Varun. Varun, I don't know if I have the sharing rights, but I just want
Yes.
to get the presentation. Okay. Can everyone see the presentation?
All right.
Okay. Thank you very much, sir. Thank you, Mr. Ranjan, for starting off this conference on the note. And I have heard you on several occasions, and what impresses me the most about you is the clarity and precision with which you present your views as being amongst an important champion from a tax policy perspective. Thank you, ASSOCHAM, Mr. Rana, Varun, for giving us this opportunity to partner with you. And essentially, we, in our capacity as knowledge partners, have tried to assemble views from an industry standpoint. We have, of course, brought our experience at a practical level, which includes not just working with clients, but also working with the tax administration in trying to understand their point of view, and also participating in multilateral discussions as well. What you see on the screen today is just a snapshot of what the cover page of the report looks like. Varun and his team gave us hardly any opportunity in terms of time to be able to finish this study, which was fairly exhaustive, wherein we are trying to put views across from the industry to the government. And our, I liked Mr. Ranjan's, punchline message. We should understand equalization levy is not just a tax. My punchline message on behalf of the industry is that, well, equalization levy, being a very material departure from the normal contours of taxation, which is what we are trying to demonstrate, also is of a magnitude where stakeholder consultation becomes extremely critical. And I would like to use this platform and Mr. Ranjan's good offices to kind of convey that message to the lawmakers that stakeholder consultation is very, very critical. Well, I'm not going to labor on many of the aspects which are either known to us or what Mr. Ranjan commented upon. I'm going to make 2, 3 important observations and important dates in terms of the 2020 levy did not come in as a part of the finance minister's announcement in the parliament. Instead, it came as an official amendment on March 23, 2020, when the country was already in a lockdown situation, which saw the passage and the subsequent accent by the president to make it a law. Essentially, the industry had just 8 days in the middle of the pandemic to be able to react to it, and found themselves in a situation where today happens to be the first date for uh, complying with the law, and a clarity emerged only on July 4th, just few days back, which until then, based on our sources and discussions with the government, obviously the government was non-committal because the Ministry of Commerce also got involved over here as a result of the actions that United States proposed under the US Trade Act. And until that point in time, we were hoping and expecting that the government would delay the implementation of the expansive equalization levy. So that's just a starting point I wanted to make. I'm not going to get into the details of the law, sir, but I would certainly take this opportunity to be able to, uh, demonstrate to our viewers from the industry, and also like to convey a message to the government as to how expansive the law is in terms of coverage, and the fact that it applies to uh, the e-commerce operator and the intermediaries, and that's where the uh, uncertain part of the law starts, and on what does it actually apply, goods, services, and goods and services facilitated by the operator, and a combination of all three. And we all know that it applies on a consideration of 2%. These supplies that are getting covered are not just for goods and services, but new concepts have been introduced where the goods are brought and the services are availed of using an IP address located in India. And this is where the uniqueness of the Indian law comes in. And then another residuary activity, which is what is called specified circumstances, which includes sale of advertisements that targets to customers who are resident in India, and sale of data collected from person who are resident in India. And again, the common thread for both advertisement and data is that the person who is doing it uses an internet protocol address located in India. So that's and dwelling a little bit deeper into it, given the framework of the law, what are the practical considerations that are arising by way of difficulties? And this is where we really need, as ASSOCHAM, to partner with the government to seek clarifications on the law terms, such as, what do you mean by saying facilitating? Does it require any activity or a role to be played by the e-commerce player? All forms of e-commerce models are extremely complex. There are e-commerce models where intermediaries merely provide technical support. Every day we talk to clients, whether they are from banking or financial services, or they are from independent payments facilitation company, which don't even have operations in India, and they are providing these services to many e-commerce operators. And sometimes the facilitators provide the services not just to the e-commerce operator, but even actually to the entrepreneur of the business, for which they get remunerated on an arm's length basis. And hence the question that arises for consideration, in my view, is what do we mean by saying facilitation? Similarly, managing digital or electronic facility is a term that can be uh, interpreted in a very broad manner to cover far beyond what, in my view, the intent of the law could have been, which is the e-commerce service provider. Similarly, there are challenges with respect to expressions that have been used, data collected from a person resident in India, particularly if that data is not used by a person resident in India. So these are some of the aspects that we wanted to, flag off, uh, making use. The law has some exceptions to the rule, which Mr. Ranjan spoke about, where if you are liable for corporate taxes, then equalization levy does not apply. Now, I just wanted to point out two specific examples of levy of corporate tax on certain forms of non-residents, which have been a subject matter of debate and litigation, which are now at various stages, including before the Supreme Court. The first is on characterization of income, particularly if a contrarian view is taken by the revenue department that certain forms of income are royalties or fees for technical services, whereas the taxpayer argues that these are in the nature of business income. And the second form is the very closely interpreted source-based rules on the concept of permanent establishment with regard to e-commerce businesses or digitization of businesses. So these two form a fairly substantial part of disputes that we have seen in the international tax fraternity, and hence the question that begs for an answer is, what if the taxpayer wants to comply with the equalization levy law, uh, is under a bona fide belief that these forms of payments are not liable for corporate tax, for which either it is in dispute or it is not in dispute. And given the uncertainty surrounding these forms of final determination of disputes, uh, would it be subjected to dual taxation? So it goes ahead and pays the equalization levy, but it finds itself that the revenue department wants to charge corporate tax as well. And what happens in those situations? Does it get the refund of equalization levy back? Does it keep the options open insofar as litigating these are concerned? So these are some of the practical challenges, and many e-commerce players, digitized businesses are in the midst of such form of dispute. There are technological challenges in locating of the IP addresses. There are issues with regard to payments that are made by local subsidiaries of large multinationals for intra-group services or for global transactions in the context of banking and financial services. And a broad reading of the law as it stands now suggests that all of these things are either covered, or if they take a view that they are not covered, they certainly run the risk of having a dispute with the tax administration. Mr. Ranjan did cover the aspect, and I know for a fact that he has examined this with a tooth comb as to whether this levy meets with the uh, test of the constitutional validity. Well, our view is that if we compare the 2006 law and 2020 law, there is a difference. Perhaps the 2016 law did not come up for as much of an intense debate from a constitutional law standpoint as the expansive 2020 levy comes in. Our humble view is that the 2020 law, uh, which I'm glad is not particularly not considered as in the nature of a tax, or at best an imperfect tax, does suffer from certain infirmities, particularly given the fact that under the GST law, and prior to even the GST legislation of 2017, under the 2016 expansive definition of qualified services exigible for service tax, does cover these services under the OIDAR. OIDAR is essentially certain specified forms of services provided by non-residents where the service recipient is in India. This is classic under the service tax and the GST law called taxability under the reverse charge mechanism. And hence, the question that arises is that though the equalization levy is expansive beyond the OIDAR, because OIDAR envisages not just e-commerce but also a wider range of services. What happens if a taxpayer finds itself who is currently uh, paying taxes under OIDAR as GST and also now liable for equalization levy? Of course, the levy is on two different people under the OIDAR reverse charge mechanism. It is the recipient of services which pays the GST, and now under the 2020 equalization levy, it is the service provider, the non-resident service provider, who is liable for tax. We'll discuss the compliance audit issues. Amit is going to cover a lot of that, and we'll try and discuss that later. But I just thought I'll also mention that our privacy law has been a subject matter of debate in the country, and there is a draft e-commerce policy taking shape. There is a draft law as well, which is up for debate. And now we have gone ahead and in equalization levy for identifying the nexus through the use of Indian IP address. All of this does throw up a muddled debate insofar as the non-resident e-commerce service operators are concerned from a larger business standpoint as well, something that we have also captured in our findings. This slide essentially is to be able to list down the differences between India's 2020 expansive equalization levy and other forms of digital services tax, as is popularly called across the world. Uh, I mean, the does not all suppliers of digital goods and services get covered is basically, I mean, in this slide, we've essentially raised some questions rather than offering any solutions. I think the most important point is, unlike the digital services tax, the 2020 equalization levy is not specific to any form or species of digital supply. So, well, today the count of countries going up on such form of taxes is increasing actually every fortnight, not just every month. We just took a count yesterday, and KPMG has actually an app that tracks these forms of levies by various nations and what the important features are. If I'm not mistaken, the last number we checked was 27, and in the report, we have identified all the countries, their scope of coverage, their rate of tax, the date of applicability, because there are certain countries such as Indonesia that have gone ahead and introduced the law and then deferred the law based on the stakeholder consultation that they've had. So this is a very dynamic situation that we are experiencing on the wider DST debate. And of course, India is very much a part of that debate because of its 2020 levy. But suffice for me to say that unlike DSTs of most, if not all of the nations, which are very, very specific to certain species of digital supplies, India is a far more expansive in its approach. Well, to some extent, we've tried to put down views of all stakeholders. When I compared the 2020 levy, it kind of reminded me of some of the principles that were articulated in the income tax amendments in 2012 on under the deemed fiction provisions, where we said that the Indian law does extend even to transactions which are exclusively between non-residents. So to a larger extent, that message is coming out loud and clear, something that we have analyzed as well in our findings. Now, uh, I'd like Dr. Kathuria to focus on this as an economist because he's actually an expert. But because we took a wholesome approach in our report, and we did get an opportunity to debate this with the internal ASSOCHAM team, seeking views from some of the members and players, we just thought that we'll put out a couple of slides on what all of this mean. And these are not at all tax considerations. I think Mr. Ranjan also highlighted that you're dealing with an imperfect tax, but there is a larger context to it, and those contexts are circumstances and several other aspects, including economic and geopolitical aspects. And interestingly, these geopolitical aspects have become more relevant, more so in the last few weeks. We've covered all of those developments in the detailed study, what those geopolitical developments mean, so on and so forth. But I just wanted to focus my last few slides on the impact to the digital service providers and also to the consumer behaviors as we have experiencing it. Few of the critical considerations only from an Indian market standpoint as is the impact that we should assess on the Indian players and the startups, particularly given some of the larger flagship programs that the government is pursuing with a lot of enthusiasm as a part of its larger public policy agenda. The role that these market players in the digital ecosystem are likely to play, these have to be analyzed, and chambers such as ASSOCHAM should take a lead, in my view, to conduct an in-depth study of the equalization levy on some of these aspects and present it to the government. The 2020 levy differentiation between various types of digitized services. So, in this slide, we have just pointed out that now with the 2020 levy, there is no difference between an online shopping uh, or cloud computing services, because everything has been clubbed into one. How fair is that, and how reasonable is that, is a question that comes up for debate. Facilitation for supplies now are taxed at the same rate as the supplies itself. Now, when you look at a lot of these businesses which are intermediaries, which is what is called as facilitation, really they are working on wafer thin margins. And the question that we need to debate is, should those be taxed at the same rate? I'm reminded of a very nice principle that has been there in the income tax statute, which is the TDS on contractual payments. So it has two rates. It has TDS rate of 2% on contractual payments and 1% on the subcontractor payments. So the design of the law suggests that there are contractors, but the margins for a contractors may vary on whether you're a main contractor or a subcontractor. Some of those concepts have been there in the statute. I think it's worth, in my view, to look at some of those aspects. This is just to be able to illustrate the point that I'm making in the context of a supply versus a facilitator for a supply. Uh, Impact assessment, in our view, is very, very critical. This clearly has an immediate impact on the cost of services, which really impacts the consumers, something that we have covered in our next slide. And some of these points that we are making are really the infirmities that we are trying to point out. Whereas ordinarily you will get deduction for such costs and expenses, it is unclear whether these costs will be allowed. Though I had a very interesting debate with some of the officials of the Ministry of Finance on the weekend, and they seem to suggest that insofar as the resident service recipient is concerned, and I would say that this would more be in the context of the B2B transactions, that he would be able to cover, to claim deduction of these costs. But let's see what the FAQ suggests. So the double taxation point that I made earlier stands. There is very little guidance that's available on many of the open issues. We all know that, something that we will debate. The domestic service provider, in my view, seems to be disincentivized because the 2016 levy suggested that all of these costs are eventually pushed to the recipient of services. Now, in the context of 2020 levy, these recipient of services could be businesses or could be consumers as well. And that brings me to the final point on the impact on consumers. Increased cost of consumption, and hope that this does not change the preference of the consumer from digital consumption. Different forms of impact that I talked about, whether you're talking about a B2B model or a B2C model, but they ought to be, in my view, analyzed thoroughly, which, given what I stated in the first slide, insofar as the timing of the law is concerned, doesn't seem to have been done. We also need to analyze the impact of the equalization levy on small and medium enterprises. Now, interestingly, the small and medium enterprises, as we are aware in the last few years, have been trying to get on to the bandwagon of digitization in order for them to be able to push the fortunes of their businesses, because their businesses models are the ones that need the digital platform the most. Now, they will find themselves in a situation where the cost of their products and their services in order to get to the consumers, whether it's the last mile connectivity or the intermediary of a B2B supply model, will suffer this cost. And that's something that we ought to evaluate. My final few points are more for debate and discussion, but I think these are larger policy perspectives that we ought to analyze. Well, this is simplistically stated. Yes, this is not just a tax. It is certainly a wider issue. It is debatable whether uh, the tax policy considerations have been coherent. I take the point that has been made in the context of what other nations are doing, as well as sympathetic towards what the current need of the government is, which is bolstering the tax revenues. But on the other hand, equally important is the point that India now finds itself at the center of the digitization and the digital debate as a part of its larger public policy. And hence, we ought to bring the tax policy coherence part of this, because our public policy push on many of the social programs and many of the things that we are trying to do for the small and medium enterprises are equally critical. And then comes the geopolitical part of it, which is the developments that we have seen with the US 301 investigations. And finally, the investor sentiment, which are also equally important. So with that, Varun, I hand it over to you for other panel members to express their view. But the draft report is with ASSOCHAM. I'd like to say we are just giving final touches purely from a design standpoint, and ASSOCHAM is going to release the report later today. And I'd just like to thank ASSOCHAM and his team members and my team members, particularly Tarun and Shanky, for helping us put together. I just hope that you find this report informative, but please do not just keep this report and read it, act on it. And I'm confident that we would build a stronger ecosystem in the digitized space, as well as a more resilient tax policy. Thank you, Varun, and thank you, everyone.
Thank you, Mr. Bhutani. Can I request Dr. Rajat Kathuria, Director and Chief Executive Career, to kindly address?
Thank you, Varun, and thank you, ASSOCHAM, for giving me this opportunity. I think coming after Akhilesh ji and Mukesh on this extensive and very, very persuasive presentation made by both of them, I think I have nothing to add. That's what Akhilesh ji said about the tax system. Let me say that, you know, we are at a time in our economy where things are even worse than we thought they were. And therefore, the government is trying to sort of latch on to anything that it can in terms of generating revenue. So let me be specific and try and nudge this debate in the manner in which Mukesh suggested at the end, to see where India's ambitions, especially in the digital economy, could be, and whether there are any trade-offs that we need to be worried about. So we have ambitions of creating a digital economy of $1 trillion by 2025 or 2024 in the context of a $5 trillion economy by the same time. And I think that aspiration or that ambition will have to be pushed back. From a growth rate of 5% in December 2019, and we were debating whether 5% or 4.8% was really the right growth rate, to a time when we are looking at almost minus 5% or minus 4.5%, the latest estimates, and who knows where this could be depending on how much time the lockdown goes on for and how we lift it. We're looking at really desperate situations in terms of the growth rate of the economy. So the growth rate has been extremely low and will be very low going forward. And even the potential growth rate, so even in the medium term, I think our growth rate is we have to have a new normal. So rather than being the fastest emerging market in the world, we'd probably be looking at a growth rate, even the medium long-term growth rate will be a new normal, and somewhere in the range of, depending on who you believe, it could be in the range of 5 to 6%, much lower than the 7 to 8% that we were expecting. Given that situation, and given that the tax to GDP ratio of the government has come to has always been low, and now tax collections are low, the ability of the government to spend on public programs, which is absolutely essential today, or the fiscal space for the government, if not vanished, it's extremely low. So the government will have to look at ways of monetizing its deficit, and I think that will happen during the course of time. But at the same time, it's looking to draw as much revenue as it can from the sectors that Akhilesh ji said, sectors that are presumably doing well. And the natural tendency for government to look at sectors, I mean, it's been the case in the past that there are sectors that have been subject to high levies, regulatory burdens, and I myself have worked a lot in the digital economy and the telecom sector, and I know for a fact that the telecom sector for many, many years felt, and sometimes justifiably so, that it was treated as a cash cow, and there were substantial burdens in the telecom sector, not only in terms of license fee, but also in terms of spectrum auctions. And one often wondered whether having both spectrum auction revenue as well as a license fee on operators were justified, in the sense that you collected auction fee and at the same time also collected license fee. So when you had one, you could probably, government could consider doing away with the other. But the telecom sector often complained, and sometimes, as I said, justifiably, that it was being burdened with a lot of taxes and a lot of regulatory burden. But it was a sector that was growing very rapidly. There were times in 2008 and 9 when you were adding more telephone lines than you added since the time of independence to 1994, which is when the sector opened up. So 10 to 12 million lines were being added. So it was a sector that was doing well. And it's an open debate whether the fate of the telecom sector as we see it today is whether where it is today, and the telecom sector really is the backbone for the digital economy, and hence I'm spending a little time talking about what we've done to the telecom sector. And it's an open debate whether the fate of the telecom or the status of the telecom sector today is partly driven by the policy regime of the government. And if it is partly driven by the policy regime of the government, then there is a learning that we can use, extend to the digital economy, and certain actions which the government may consider sort of taking or not taking, given what impact it will have. The other point, I think, which Akhileshji mentioned, of course, the signal, and one expects that given the situation not only globally today but also internally, I mean, the signals are extremely important. And I think it's absolutely true. Partly this levy, equalization levy that we're debating today, in part it is economic, but in part it is political. And there was something that you mentioned in passing, but I think it's important to sort of analyze that even more, which is, can it play a role in India's international negotiations? Is there a part in this levy that is being used to signal the intent to negotiate in terms of our sort of international negotiation? And the reason I bring this up, although Akhileshji, I think he mentioned this just in passing, I think it needs to be put on the table and discussed. As Mukesh said, there are lots of things that need to be put out for discussion. I think this is something that needs to be put on the table as well. What does it mean for our international negotiations? And I would like to bring sort of an analogous sort of feature of the global economy. If you look at Brexit and what the UK is doing in terms of its tariff rates across the world, and how other countries are going to, what tariffs they're going to face to make sort of sell in the UK. One of the things that the UK has done purely from the point of international negotiation has imposed tariffs on things, especially on agricultural commodities, that it does not produce and it doesn't need to protect at all. I mean, there is no, and of course, there is also a seasonal levy in those tariffs. And a lot of trade economists have been wondering, why is it that the UK is imposing tariffs on items that it doesn't need to protect or it doesn't need to produce, in spite of the fact that it's likely to lead to an increase in the price to the ultimate consumer. And the answer is, when the UK begins to negotiate trade deals with member countries, then it could use it as a tool, as an instrument for international negotiations to try and win some gains elsewhere in items of its own interest in those markets. So I think, there is sort of a feature of trade negotiations that might be embedded in the equalization levy, or we should at least discuss that. Although, at a simplistic level, this just seems that the government is short of revenue, the digital sector is doing well. In fact, it is the only sector that is doing well, and this is an opportunity for the government to get in some much needed revenue so that it is able to spend. This is not spending on public policy programs. This is probably spending on trying to ensure jobs, trying to ensure social security payments, and trying to make health expenditure. The sort of spending on public goods will come much later, when we begin to revive and transform the economy at a later stage and have a better social security and a better sort of architecture for making social security payments, and a better sort of medical system, better healthcare facilities. I think those will come much later. At this point, the government needs revenue just to be able to maintain sort of jobs, try and ensure people have money to spend on their livelihoods. And I think jobs is something that also needs to be discussed. Now, of course, there is sort of a trade-off here, as well as Mukesh was mentioning. What is a feature of the economy that is a potential sort of ticking time bomb for India, given India's demographics, given India's number of people that are coming into the labor force? And I think the labor market is one, and the pandemic has brought that clearly out in the open. We have a huge informal sector, we have a gig economy, and we have no social security, almost no social security in the informal sector. And one of the things that the government is probably wanting to do, and should do, I think, is extend social security in informal sector workers. Otherwise, this is not something that can continue in India. It is not sustainable, whether it is in the form of social security payments, whether it is in the form of UBI, whether it is payments or liquidity support to small and medium enterprises to ensure that they don't fire people, etc., whatever form it is, but this is something which is absolutely essential. So on the one hand, you need revenue to be able to support jobs, and you also need revenue to be able to ensure that people have enough money to meet their livelihoods, and there are in-kind transfers and there are in-cash transfers. At the same time, you don't want to, as Mukesh was saying, increase the burden on companies and small and medium enterprises that I think have been the vehicle for creation of whatever jobs that are created, exports, jobs. It is really the small and medium enterprises that could be the vehicle for job creation, whether it's in the formal sector, whether it's in the informal sector. And therefore, the impact of this levy on the small and medium enterprises and what the compliance costs are likely to be on those enterprises, which could be a vehicle for job creation, which could be a vehicle for stimulating the economy, because small and medium enterprises have enormous backward and forward linkages to even big players, as well as on the backward linkages side to the small and medium household level enterprises in India. So the small and medium enterprises link both forward and in a backward sense, and could be the vehicle for job creation. So in case the impact, already we have seen the impact of GST has been disproportionately felt on the sort of small and medium enterprises. And then we were coming from a history in 2016. You had demonetization, then you had the GST, and the burdens did fall. And there's some research that suggests that the burdens did fall on the small and medium enterprises. And in case the equalization levy has a disproportionate impact on them, I'm not saying it will be, but this is something that ICFER will be happy to do, given that we've done compliance cost estimates of paying direct taxes in India, both on big enterprises and small enterprises. This is something I'm putting out on the table for discussion, and we're happy to do that. And Equalisation was on the other side of the table when we were doing this study and being familiar with this study. And we'll be happy to do that. And I think it's important that we are able to do that in a scientific manner, so that instead of saying what our gut feel is, we can have actual estimates on what's going to happen to those enterprises that are going to be, I think, that are going to be sort of the avenues for job creation in the economy that is increasingly feeling the burden of not only job loss growth, jobless growth, but commentators today are calling it job loss growth. And as I said, that this is the most important fact of future of the Indian economy today. We have to be creating jobs in the absence of any meaningful social security architecture. We have to create jobs. Otherwise, we could have a really drastic situation on our hands going forward when we're looking at a recovery. And the last point that I wish to make on this is that we have been participating in international negotiations around on e-commerce. We sort of pulled out of the e-commerce negotiations in the WTO. We are not participating in that, and there are some reasons why we are not participating. I'm happy to discuss those in the question-answer sessions. This is something that already is in sort of the OECD, as Mukesh and Equalisation both have mentioned. We're already sort of discussing, India has a representative in the OECD, and we're participating in the discussions and the negotiations on digital taxation. And therefore, even before those have concluded, I mean, in fact, of course, it is sort of an economic and political necessity. Even before that has happened, we sort of imposed this levy. Maybe there are good reasons the government did it now. Maybe we couldn't wait. But I think this suggests that there is some element of unilateralism, and I think in the levy, which could sort of be discussed, which could have been discussed before it was imposed. So let me conclude by saying that it's we recognize. I mean, I appeal to Paul Krugman, a very respected economist that I love to read. He's an international trade expert. He wrote a very sort of influential article many years ago in Foreign Affairs, and it was called "A Country is Not a Company." And basically, the argument is that governments or people who are working in the government are looking at economic policy or tax policy from a general equilibrium framework. They don't necessarily look at it from an individual firm or an individual sector specific framework. And I think that's right, the general equilibrium, because the impacts But that also begs the question that if you are looking at something in a general equilibrium framework, you would want to sort of explore and examine the impacts, or at least go through the impacts of introducing something that is new on the economy, and explore the impacts over the economy before taking a decision. So looking at it in a sort of a more sort of holistic way before an important introduction of a tax such as this impact. And by that I mean looking at the impact on the sector, impact on the downstream impacts on labor market, so that you are able to sort of nip in the bud any adverse impacts that it may have on the sector and therefore in the economy. I'll stop here. Thank you very much, Mukesh and Equity for having me here. And I look forward to the presentation of Amit Rana. Thank you.
Thank you, Dr. Kathuria. Can I request Shri Amit Rana ji to kindly address?
Thank you, Varun. Good afternoon, everyone. So I'm following after Mr. Ranjan, Mukesh, and Dr. Kathuria. A lot has already been said. I think clearly there is a debate which Mr. Ranjan set up, which is whether this levy should be there, should not be there, what is the efficacy, etc. So that's one piece of it. And as a practitioner standing today on July 7, which is the first installment of equalization levy, for me, I think there are also other things in implementation which are worrying, and I want to raise those in this discussion today. Mukesh did set up the law for us, and one of the things that we as practitioners are seeing in the law, of course the law is wide, but then this is not the only law which is wide. I mean, there are various other provisions, laws which are wide, and therefore in interpreting such widely worded law, we have to refer to various aids of interpretation. And one of the main aids to interpretation is the intent of law. Now, one of the big issues that we are facing as practitioners when clients are actually saying that, okay, it is what it is, the law is there, we have to now follow the law and do the compliances. But when it comes to interpretation, absent that clear articulation of intent, what is it that the government was intending to tax through this equalization levy, that is not there. And let me explain that a little. Usually any law comes with a statement of objects and reasons, which is explained by the government in parliament, in other documentation that accompanies the law. The 2020 equalization levy does not have that. Admittedly, when the law of equalization levy itself came in 2016, when it was only covering advertising revenues, at that time there was an intent, but the 2020 law is so different from the 2016 law. One basic difference is the 2016 law was a deduction. This is a final tax on the provider of service and supplier of goods. So can we really rely on intent from 2016? And that is one big shortcoming in our ability to interpret this effectively, and therefore this whole thing is coming up that, oh, is this really as intended, as widely as it is worded? And now let me come to the second issue. The basic definitions of an e-commerce operator, which is the person on whom this levy applies. It says e-commerce operator is a person, as a non-resident, who owns, operates, manages a digital or electronic facility or platform. Now, this definition, there are various parts to this definition, but the two parts that I want to focus on, it says e-commerce operator is the taxpayer. And then it goes on to define an e-commerce operator as someone who owns, operates, manages a digital or electronic facility or platform. Now, if I only look at e-commerce, and then I look at the guidance, how OECD and BEPS has been looking at e-commerce, they've typically been intending to cover marketplaces, user value creation, and those kind of models that are coming up because of these new technologies and newer business models. So do I look at e-commerce in that fashion? But the law, by the way, doesn't say that it's trying to address the concerns raised in OECD. So maybe I cannot rely on that, the whole discussion in OECD. Then it goes on to say, owns, operates, manages digital electronic facility or platform. Now, each of these phrases by themselves can be looked at so widely that almost anything can get covered in a digital electronic facility platform. Almost no business today is done where it does not use some form of digital or electronic technology platforms. I mean, that's just the way the new business is done. And even old businesses, traditional businesses, are all done through these modes today. So even a traditional engineering company will have a website through which it would want to sell, reach to customers. Even a traditional EPC company will have those kind of outreach through websites or other platforms. All companies will use internally some of these platforms for intercompany services. So is that really the intention, that we want to cover the whole wide world within this levy? And because there is no clear articulation of intention, maybe that's where we have to go, because we can't rely on any restrictive conditions because they are not existent in the law today. So that is the second aspect. The third aspect I would raise is just the way the law has come in terms of timing. Again, Mukesh did mention that, but I still want to touch on this. 23rd March, this law was passed. It became effective April 1. We had some informal conversations with government, and I think the feedback from them was that don't worry, the first installment is due only in July, so there will be some guidance available. Now, I think we also really appreciate the fact that we are in an extremely difficult environment with COVID, and even in the government outside, there are all of these cases happening, and people are not available, because of which possibly clear FAQs, because in a law which is as widely worded as it is, FAQs are very critical if someone wants to comply with that law. Now, given all of the situation, probably the government could not come out with FAQs. But then, they introduced or amended the Equalization Levy Challan of 2016 through an amendment in the online challan. There is no formal notification or circular or any change of rules that's happened. And that happened on July 4th, through this online change. And now the first compliance is due today. And by the way, many of these e-commerce players, digital players, companies which operate in this space do not have a history of, complying with tax laws of India. So they do not have even basic registrations. But this challan now requires them to register, obtain a permanent account number. So, I mean, very, very procedural aspects, but I'm telling you, when I speak to clients, very relevant, because clients do want to comply 100%, and unfortunately they're left in a situation where they cannot comply because this guidance came too late in the day on July 4th. So I guess there is something to be considered by the government, that uh, even if they want people to comply, even if they want people to pay the taxes, there should be enough and more available from their side to enable people to comply, to make it simple for people to comply. And that is an aspect for the government to consider. Even now, because people will not be able to comply on July 7th, hopefully there will be something that will come out that interest will not trigger if you don't comply on July 7th. But I'm just hoping that will happen. Otherwise, people are looking at even interest for these delays, which are honestly not because of any reason on part of the taxpayers. The fourth point I would make is on, Mr. Ranjan also mentioned this thing about this law being an option. you could go under traditional law or under the equalization levy. So the way the law is crafted, uh, it is a separate chapter under the Finance Act, and therefore it's not within the income tax law, really, the Income Tax Act, under which we usually pay our income taxes. And that has a whole different debate, but we're not getting into that. So it is in this separate Finance Act, but because these are also flows which could get taxed under the income tax law, therefore there is a specific exemption which has been mentioned, which says that if you are exigible under equalization levy, then income tax will not apply to you. So there is a specific exemption which has been introduced in the income tax law. But again, the timing of that, so while equalization levy applies from April 1, 2020, the exemption, the way it is worded today, and we hope that will again get clarified, the exemption says it will apply from April 1, 2021. So therefore, there is one whole year running where, at least in theory, a tax officer can ask a taxpayer for both the traditional income tax, if he believes the overseas player is exigible to the traditional income tax, royalty, FTS, or and equalization levy. So this is another aspect. Again, government has been pretty vocal that this will hopefully get clarified, and we would love to see that in the final clarification that come out. But that's another area which, as we stand today, clients are asking, okay, should we comply because we fall within this? And as tax practitioners, we don't have a clear advice to them that should you comply, because the language is that actually the exemption kicks in only next year, whereas therefore for FY 2021, both the traditional tax and the equalization levy can apply. And then just in the interest of time, I know we need to have a discussion and a debate as well. I will also make some procedural points very briefly. The law also extends to sellers who are selling to buyers who use these goods or services using an IP address in India. One simple example of this is, I have a cousin in the US. He has a account with a streaming video company, and he watches movies on that. He takes and buys that service. He lives in the US. He's there. He comes to visit me in India for 2 days, and he watches that content while he is in India. Obviously, he'll use an IP address which will be in India. So the expectation as per the law is that that streaming company should be monitoring the usage of every user of that company anywhere in the world. And the moment that user touches India and he uses that service or he buys a good while he was sitting for that 1 day in India, they need to proportionately pay equalization levy in India. Now, admittedly, digital companies are very savvy, and they should be able to actually pinpoint with accuracy that yes, this Amit Rana's cousin was in India for these 2 days in a year, and therefore that part of the revenue is liable to EL. So go ahead, pay the EL. So admittedly, I think digital companies should be able to, but that is a whole amount of investment that will need to be made by these companies just to fix this. And is it really commensurate with the amount of revenue that the government will make? And then there is no way the government has the ability to even validate this. There is no way technologically, other than just rely on the service provider. If he says, okay, $10,000 earned, the government will have no option but to rely, unless they want to go and do a systems audit of the person. So these kind of things in the law, procedural, but very, very important. If a taxpayer wants to be 100% compliant, then people are scratching their heads that what do we do with something like this? The volume of this will be so low, but I'll have to spend millions of dollars just setting this up. So should we really set it up? Can the government be a little more practical on some of these things and not impose these? Then there are things, this law, just in the way I think the government had less time to implement it. So they've simply amended the 2016 levy and just imported many of those provisions or used them in the same way as they were in the 2016 levy. But the 2016 levy was a deduction by an Indian person. This is a tax on a foreign person. So there are differences between the two. As a deductor, beyond a point, I did not care too much. I could be conservative and therefore just deduct the tax and let someone else deal with the problem. But as a final taxpayer, people will need to be very careful. So something as basic as appeals, the law today as it is worded does not have a provision for appeals on any aspect of the law other than penalties. So the appeal provisions say that appeals can lie only for penalty, but not for anything else. So again, this probably needs a little more detailed review by the government to ensure that the procedural aspects, appeals, etc., are commensurate or address the law as it stands today, and not merely, rely on the law as it stood in 2016, which was a little different law. Another aspect is advance ruling. So, given the way this law is, this whole business models are very new. We should be allowed to go have advanced rulings on this. That also is not there. So some of these procedural aspects probably will be helpful if the government in the FAQs or through legislative changes can bring these about. So there are a lot of other things which the government can address. We've made representations as well. ASSOCHAM, I'm sure, has made representations, and we hope someone is listening and we will get some good guidance soon. Mukesh, back to you.
Hand it over to Varun. Varun, do we have some time for
Yes.
a session? Because there are some, besides some interesting questions, we felt that we should make use of this platform to seek some clarifications from Mr. Bansal, Mr. Ranjan from a larger policy perspective.
Yes, Mr. Bhutani,
Okay.
we have time.
Okay. Mr. Ranjan, I think what would be useful is if you can share with the participants as to, you did allude on it by talking about the uncertainty surrounding the consensus approach under the unified framework. What, in your view, you see as the challenges for such consensus, and if at all the consensus is not achieved, do you see such proliferation of unilateral levies continuing, and digital players getting into a chaos kind of a situation as a result of that? Because I think certainty for business would be very critical in the COVID period.
Yeah, Mukesh, I think that's a worrisome sort of prospect, but it is quite real at the moment. It's possible that there may not be complete consensus. The earlier deadline at the G20 had asked the inclusive framework to evolve a consensus by the end of 2020, which I think now almost everyone accepts as it is not possible um, due to COVID, due to various other reasons. But then the hope still is that we can, by early next year, by March or something, by April, come to some agreement. Well, efforts are being made. I mean, I think the OECD and the inclusive framework, people are very involved at the moment. What I know of it, I think there are issues which are getting resolved very fast. The only problem is now that uh, what sort of solution will there be, which let's say the one of the major players in the world, the US, also agrees with. And what will make the US say that okay, this is something that we can live with and be part of? Because if they say that look, sorry, this is not really to our liking, and we would like it to be only in the form of a safe harbor or whatever, then the meaning of a full consensus really eludes us. I mean, where is the consensus? Then there are countries which are just waiting for that situation to arise. If there is no consensus, if there is no possibility of a long term solution based on normal corporate tax, then these are countries which are waiting to jump onto the bandwagon and have their own levies. The European Union has said it very clearly. They already had a proposed DST, which I think they will not lose much time in trying to bring in. And if that happens, I mean, that is going to be I don't know, there could be some massive repercussions of that, not just about double taxation, but about larger issues and conflicts between uh, trading blocks in the world. I think that's something that and then probably maybe people will have to think about trying to evolve a consensus on the DST itself, and that's not a bad idea. If you can, if it's not possible to have a consensus on normal corporate tax principles, then let's all sit down and evolve a uniform DST, a service tax, or a digital services tax, in which all countries are on the same page and there is a mechanism for resolving disputes and giving credit. So maybe those are just prospects. We are not going into that just now. As I said, the inclusive framework and the OECD and all countries, including India, are trying very, very hard to somehow come to a solution, to a consensus we all agree to. Maybe not a very perfect solution, but a good solution, which we can carry forward in the years to come.
Dr. Kathuria, you made a very dispassionate plea and emphasized on the importance of the impact assessment. I liked some of the points that you made in the context of jobs, in the context of labor challenges in the pre-COVID area. Clearly, from a public policy standpoint, there are several challenges before the country. Um, and in light of all that we see, what would be your policy prescription and advisory to the government in the context of equalization levy? Should this be a solution that would be not just an interim solution because of the risks that Mr. Ranjan pointed out with respect to failure on the multilateral front? What would be your situation? Because on one hand, we want investments, we want digitization, we want to promote the larger digitized agenda. On the other hand, we also want revenues to be able to sustain the spending of the government, and perhaps now in enhanced spending on healthcare and other challenges that engulf us as an economy. Okay. Um, Varun, are you able to see Dr. Kathuria, just in case he's on silent or something?
I think I'm.
Yes, he's there. He's very much there.
Yes.
I think, thanks, Mukesh. I think that's a sort of a very difficult question. I think the government needs revenues to spend on social security and public programs. And at the same time, I don't think it's fully cognizant of the fact that, what the compliance challenges are going to be and what the impact of this equalization levy is going to be on the economy downstream. I don't think sort of they've exactly worked that out, but the need for revenues, immediate revenues due to COVID has prompted this. And whether, I mean, if the impacts turn out to be there's a lot of litigation, there's a lot of compliance costs, if all of that happens, then I think you might want to reconsider this, especially in the hope that there is a consensus that is developed internationally. And I think the G20 is the right forum. The G20 has a good history in terms of being able to develop a consensus. But I think today is extremely divided and extremely polarized. And what doesn't help really, and I don't know how to sort of say this, but or sort of characterize this, what doesn't help the big tech really, or what doesn't help the big companies, is that the narrative around big tech is quite divisive and very polarized, and sort of they are sort of equated with being sort of big bad monopolies abusing consumers, getting data, using private, using private data for benefits. That's the narrative around big tech, and there's a huge tech lash that is happening. That's the global narrative, and unfortunately, what happens as a result of that is that there's a lot of, as economists say, that the good and the bad, they get sort of confused, and that makes for policies that may not be in the interest of the economy as a whole or in the interest of the sector. So I hope that if there is evidence that builds up on what the impacts of this levy are and what they're going to be, not only in India but in other countries, that have introduced this levy, what those impacts are on the economy, and hopefully, as I said, if a consensus develops, then the government can sort of recalibrate what it intends to do. But there will have to be, I mean, the subtext of what I'm saying is, from the tech companies' point of view, from the big sort of companies' point of view, there has to be an attempt to try and bridge the deficit that is growing on the lack of trust between big tech, government, and civil society. And as I said, as a result of this, a lot of small companies feel the heat, feel the pain. So that, at a larger level, that narrative needs to be addressed. I don't know if I'm sort of conveying what I want to say, but that narrative needs to be moderated. That narrative needs to be addressed.
Yeah, thank you, Dr. Kathuria. In fact, one of the aspects that in the study that we are perhaps not competent to do has been to assess the impact of this on the small and medium enterprises who are getting on the tech bandwagon and who would be impacted more. But I think your point is valid. Amit, there is a question for you as well. If you want to take this, does equalization levy cover intra-group service charge, which is the management services or technical services or any form of similar reimbursements? Are you there, Amit?
Amitji, you're on mute.
I'm here. Sorry, I was on mute. So, Mukesh, I was saying that the law as it stands does not give any exception or make any exclusion for intra-group, which is transactions between two entities of the same group, and a different transaction which is with a third party outside the group. What we need to see is whether the contours as laid out in the law, which is whether the provider of that activity or service, does he classify as an e-commerce operator? So therefore, does he own, operate, or manage a digital or electronic facility or platform? If he does, and he is rendering an online service or selling goods online to an Indian person, which may be a group company or maybe a third party, that can get covered in this. And this is one of the challenges with the law, that I really don't have a ability to distinguish. Someone would argue that why should an intra-group service get covered in this? But the law looks at everything just objectively. The law has laid out principles. If your transaction falls within those principles, doesn't matter you're within the group or outside, it can get covered.
Thank you. Varun, we are dot at 2:30. I'd close the webinar.
Thank you, Mr. Bhutani. Can I request Shri Ashwini Rana ji, the co-chairperson of the ASSOCHAM National Council on IT, ITS and E-commerce, to please propose a vote of thanks?
Thanks, Varun. So I would like to say big thanks to all the participants as well as presenters. I'd say we got benefited by your views from, I'd say, broad spectrum of issues. So thank you so much. I will not go into making summary of that. It is already done by Mr. Mukesh Bhutani. So thank you so much, Mr. Akhilesh Ranjan, Mr. Bhutani, Dr. Kathuria, and Amit Rana. We look forward for more such engaging discussions going forward at ASSOCHAM platform, and thank you so much.
Thank you.